I'm Gary Nitzkin. I'm an attorney with Credit Repair Lawyers of America. We're the muscle for credit repair companies around the country. When you cannot get something off the credit report the nice way, we do it the hard way with litigation. If you do credit repair in return for money, you're governed by the Credit Repair Organization Act, or CROA as we call it in the industry. This is a statute that was passed by Congress to punish the industry for the acts of a few bad apples. On this website, I discuss the statute in depth. Let's talk about some of the more important things you need to know about the statute. Your contract must be CROA compliant. You have a written and signed contract from everyone for whom you do credit repair. Inside this contract, there are certain disclosures that you must make. I'm not going to list them here. You can get that off of the web page. Your client has 3 business days within which to cool off, and he may cancel the contract anytime in that 3-day business period, or I should say 3 business day period. Some states have laws that extend the 3-day period even further. If you do any work inside that 3-day cooling off period, the consumer may demand his money back and you had better give it back to him. You must give the consumer written notice in duplicate of their right to cancel their contract in 3 business days. The format of this right to cancel is also prescribed by statute. Read the web page, look at the statute. Fortunately, the statute's not complicated. You may not charge fees in advance of doing any work. This is one of the less popular features of the CROA. You may only charge fees and collect money after you've completed the work. Hence, if you're a pay-per-delete company, there's an argument that you must get all of the negative items that you were hired to delete removed before you can collect money from the consumer. Of course, the industry has a different standard that as long as you complete the items that have been deleted, you are then entitled to payment. Don't get creative with this part of the statute. Some people think that an escrow account is a good idea. Others think taking a prepaid card is a good idea. In truth, neither of these is a good idea. Don't skirt the rules. The FTC enforces the CROA. Don't think you're going to fly under the radar. If you decide to practice outside of the CROA, you're asking for trouble. I was once the target of an FTC enforcement action. I gave an interview on National Public Radio and I said that it was okay for debt collectors to friend debtors on Facebook. In a consumer context, this might be a questionable practice. I don't think it's illegal per se. In a commercial context, there's absolutely nothing wrong with a debt collector friending a debtor. Someone at the FTC was anxious to make a name for herself and decided to sue me. While she dismissed the case after I pointed out her mistake, it was still no fun being the subject of an FTC enforcement action. My advice to you is to run your company in an ethical and compliant manner. I'm living proof that even when you do so, when your company is in compliance with the law, there are still some governmental yutzes out there who are anxious to make a name for themselves. Be aware that some states have their own version of CROA that are even more stringent than the federal statute. For example, California has a version of the CROA that's extremely unfriendly to credit repair companies. You also need to be aware of your state laws regarding business formation, business taxes, and regulation, especially of credit repair companies. Look, I don't mean to get you paranoid, but I want to make you aware of the laws and regulations that you need to know about before you get into the business. I really can't help you much beyond the Credit Repair Organization Act. I do know at least one attorney that handles regulatory issues for credit repair companies. If you need a referral, please let me know. Thank you.